Right, good morning and welcome to this meeting of the local review body of the 6th of March. I can confirm that the meeting has been properly called and is quorate. Can I please ask members to appoint a chairman for this meeting? Thank you.
Councillor Driver.
Okay. Thank you, Councillor Driver.
Good morning, members. Welcome to this local review body on the 6th of March at 10:30 in council offices. Can I ask for any Sederunt and Apologies? There isn't any, is there?
No, 5 members present, no apologies.
Thank you. Are there any declarations of interest? No. Can I ask the clerk to take us through the proceeds?
Thank you, Chair. I can confirm there's 2 notices of review for consideration at this meeting. The first is item 4, Knocktim College, Kirkcolm, refusal of planning permission for erection of extensions to front and rear elevations of dwelling house 171541 FUL. You have the key documents and papers being the notice of review and related documents, report on handling, observations of the appointed officer on the applicant's agent's notice of review, planning application form and associated plans and supporting information, decision notice of Dumfries and Galloway Council, relevant extracts from the LDP and the photos of the application site and locality. The grounds of refusal are on page 54 of your papers, being the proposed conservatory would not be consistent with or sympathetic to the design, character and appearance of the existing dwelling house and would be contrary to Dumfries and Galloway Council Local Development Plan Policy H8 and supplementary guidance, alterations and extensions to houses. You have the requested methods of determination that the applicant has requested that the review be dealt with on the basis of an assessment of these papers alone with no further procedure. And in summary, the grounds stated in the notice of review are: the Council has not been transparent when making decisions on planning applications. This application complies with LDP Policy H8. The case officer has not given consideration to the location, which is rural, almost adjacent to Knocktim Farm. Design amendments were sought by the planning officer to either relocate the proposal to a north-east elevation or reduce proposed size. Neither of these options were viable. The proposed conservatory has a modest footprint of 16 square metres with all materials sympathetic to the existing dwelling house. There is a little solar gain to the north-east elevation and this would overlook large farm buildings. The proposals are submitted accord with LDP Policy H8 and supplementary guidance. With reference to the delegated report, it does not mention that all proposed materials would be sympathetic to the existing dwelling and immediate neighbourhood, which is in a rural setting adjacent to a farm with large associated farm buildings. The next college to the west is a flat-roofed extension. The next college to the east has a large conservatory to the front elevation. The delegated report also states that proposed conservatory would stop 0.9 metres short of the boundary, which is incorrect and misleading. The proposed distance is 1.4 metres to the boundary, with the road verge being 2.6 metres, giving a total of 4 metres from the edge of the surface road to the proposed conservatory. Since the introduction of the local development plan, many conservatories to principal elevations have been approved, and some examples are provided on page 12 of the papers with pictures on pages 16 to 23. The neighbourhood is rural and the extension would have no impact on neighbours. The mass, scale and design of materials are each sympathetic. The extension is proportionate to the overall footprint of the dwelling house and is diminutive when consideration of the housing density, livestock buildings, attached land and gardens are factored into the decision. The need for planning control is supported but must be consistent and fair and judged on individual merit. Unfortunately, for some reason or another, this has not been the case, and I hope that the local review body will agree and approve this application. You have further comments from the interested parties and the relevant development plan policies. So the main issues that the LRB may wish to consider are: does the proposal conform with the relevant development plan policies? In particular, does the proposal comply with LD Policy H8 and the supplementary guidance? Is the proposal sympathetic to the design, character and appearance of the existing dwelling or not? Is it consistent with the design, character and appearance of the existing dwelling house? If not, are there any material considerations which would indicate that planning permission should be granted to the contrary? How much weight do the LRB members wish to attach to other decisions taken elsewhere against the LDP policies when determining this particular application? So, having outlined the documents within your papers for this case, it now falls to LRB to determine whether it has sufficient information to consider this review. It's confirmed that no representations will be heard from any party today. The options available to the LRB for this and the following case today are that it can decide it has sufficient information before it to enable it to determine the review today, request further information in the form of written representations. In doing this, LRB would be required to state precisely the information it was seeking and who would provide it, resolve to hold a hearing, again specifying who would be invited to speak on what matters, resolve to hold a site visit, accompanied or unaccompanied. This can be done in conjunction with any of the above, but obviously not allow a decision to be made today. And if the local review body resolves it has sufficient information and no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination. The decision notice will include a statement of the terms on which the planning authority has decided the case reviewed. You have a planning advisor at your meeting. He's here to assist for both items. It's confirmed he has not had involvement in either case and was not the case officer or the appointed officer for either application. He is here purely to provide independent advice on matters of planning policy, law or process to the LRB. So if members are clear, no further clarification is required. I'll ask Chairman now to lead the debate and in the first instance to lead the LRB papers through the agenda papers together to decide if you have sufficient information.
Thank you very much. And just remind members, of course, that this meeting is recorded and subsequently will be available for the public listening purposes. I think maybe if we go through the photographs first and then we'll go through the papers for any clarification. Robert?
That's fine, Chair. Happy to do so. The pictures you're about to see replicate those that are produced in the actual LRB papers for the avoidance of doubt. I haven't been to this property, but these pictures have been provided by the appointed officer. So you're looking at an aerial view of the property here. This is from our database, our map database. So you can see it's a detached property. It's already got what appears to be an extension on the rear elevation to that. This is a view of the front elevation, so that faces to the southeast, and you can see the public road in front of that single track public road. The proposed floor plan and cross sections are on page 47 of the papers, and the proposed extensions are on page 49 in elevational form. So in essence, what you're looking at is on the right hand side of the front elevation there, a proposed conservatory with a transparent roof, and on the rear elevation, which we'll come on to, a lean-to extension abutting the existing one. So that is the existing front southeast elevation, which tallies with the elevation you see on page 45. So that's the elevation you see in the bottom right hand side corner. The proposal, as I say, is on page 49, so that shows how the conservatory would impact upon that elevation. This is again a more longitudinal view. The proposed conservatory would extend out into that front garden area, so it would be situated behind the dyke and on the far side of this elevation. And that's a closer view of where the proposed conservatory would go, so it would just join into the wall just to the right of the central window there. This is a view more longitudinally. It shows the existing front garden area, so the proposed conservatory would come out into that actual area itself.
Okay, thank you very much. If we just go through the papers and members, and if there's any points of clarification that you require, then we'll go through different. So the index of context is the notice of review and related documents, pages 5 to 23. Any points of clarification on that?
You say 5 to 23, Chairman? Yeah. Tell me if it's the right place to bring it up or not. It may be later on when we get into discussion, but I'll just use page 16 as a referral point. And we see a plan of a previous application, it's a 2014 application. My understanding that's the same plan and policies then as what it is now. Pretty much copy, again, it's very much the proposed local development plan doesn't change it to any extent as far as I'm aware. So I'm just wondering, was that a delegated report or was that did that go to committee?
I think that was a delegated decision. I don't know for sure, I would need to look it up, but and I could do that before the end of this meeting, but I think it was a delegated decision.
Okay, no, thanks very much. Take that as being clear. I suppose one other point in regards to that I was thinking, Chairman, is as far as, just so I've got my full understanding in regards to permittable development rights. So if this was, if permittable development rights, I think my basic understanding is that you can build up to, say it was a garage, 30 square metres is what you can build without planning permission. You already have that right within the confines of your own land within your residential area, so to speak. So this is obviously, it comes out in front of the building line, but it's well below the 30 square metres. If this was being applied for the piece, the part in particular in regards to the conservatory, if this was being built in its own right, if the applicant was just to actually submit a building warrant, what would be the circumstances? I suppose, Robert, I'm trying to understand. Would it be come forward? Would there be any planning issues? Would the planning even see that, or would it be a fait accompli that if the building warrant application was fit for purpose, it would be approved and sent back?
It needs planning permission. In this case, the conservatory in its own right, because it's forward of the building line facing a road, and it's within 20 metres of that road too. So in those circumstances, regardless of the cumulative size of other extensions, it automatically requires planning permission. So it is subject to planning control in its own right. If the building warrant was checked, a letter would be sent out advising them that they needed to apply for planning permission too.
Patsy?
Yes, it's just something that's brought up in several parts of this first part of the report, and it's whether it's a street or a road, because it refers to a street scene. And this is not a street as I would recognise a street. And I just wonder why that's been put in the report as being important, when actually it's a rural road. It doesn't seem to have any lights or lines or anything like that. I just wonder if we can have clarity on how strong that street scene has to be in a situation like this.
My view on that, street scene is a planning term in a built-up area where you have got several properties fronting a road, and you do have a street as it implies. I would agree in this case you've got a rural location, the property is isolated, it's not seen in the context of a row of other dwelling houses facing that street. So in this case I don't think street scene is really relevant. What you're looking at here is the impact of that extension upon the character and appearance of this house. It's not really seen in the context of anything else. There's not a little cluster of houses there. It looks to be fairly isolated. So you're just looking at, character and appearance in its own right. I mean, context is part of it. You've got the context of the rural area around about, but what you don't have here is a street scene, because like you say, it is on a rural road. Yeah.
Okay, we then go on to the report and handling, pages 25 to 31. Any points of clarification on that? Then we have the observations appointed officer on the applicant agent's notice of review, pages 33 to 36. Any points of clarification on that? Then we have the planning application form, associated plans, support information, pages 37 to 49. Any points of clarification? And then we have the decision notice from Dumfries and Galloway Council dated 6 November 51 to 57. And then the relevant extracts from Dumfries and Galloway Local Development Plan, pages 59 to 78. And then we have the photos of the application site, which we've just went through on that. Are there any points of clarification on that? Hearing members, if there are no further clarification, I'm open to members for any remarks or Ian.
Well, I suppose just as an opening comment, I mean, I've certainly got sympathy for the appellant in this case, looking at previous historic decisions locally in that area in regards to similar type of plan applications that have came in. Fair enough, we have to take each application on its own merits, its own individual rights, but just if we could get a reminder, I've got sympathy, Chairman, just as a matter of a starter for 10 in regards to the appellant and the case that's been put forward. A reminder of the decision that would be made today in regards to, Claire outlined it earlier, when she says to uphold, was it to uphold the appeal, or was it to uphold the previous decision?
Okay, you would be, the three options are to uphold the decision of the appointed officer, so that's basically a refusal for the same reasons, to vary the decision, that's still a refusal but for different reasons, or to reverse, which is basically grant permission.
Okay, anybody else? I do have some sympathy for this one, actually, looking at the pictures and the existing application and neighbouring properties having something similar built. I'm open to suggestions here from members whether we make a decision today, or would it be right to have a site visit on this one? I think there's opportunities here to have a look at other buildings that have similar type structures attached to them, or whatever. I'm not, I don't think I'm against actually reversing the decision either, because I think although decisions are made in the past on potentially devolved powers to officers, we have to have the same standard in our decision-making process. There are reasons for not, giving this application the right to go ahead or not. But I'm of the opinion that I think in this case we would be better reversing because of previous decisions that was made under delegated powers to officers. But I'm open to suggestions from members.
Actually, I think you can see actually both sides of the story when you read the whole report. You can understand, but I've got more, like yourself, sympathy in regards to being consistent as a council, having a consistent approach in regards to previous decisions, particularly as we understand the system as members of the council. These were delegated decisions, they weren't through the committee, which sometimes we can see why particular decisions are made, but I'd be inclined for the reasons outlined, particularly in regards to the supporting statement. It starts on page 13, for what I can see. There's a number of things in there, but ultimately about being consistent in our approach. It is actually, you could almost turn this house roundabout as well and have it back to front, whatever way. It's the impact it'll have on that local area. It's negligible because it's rural setting and so on and so forth. I'd certainly be very much for supporting to reverse the decision, Chairman, as per outlined in this particular. I'll come back to the points if needed, but I'll hear what other members have got to say about page 13 and the applicant's appeal letter.
Any other members? Jim?
Thanks, Chair. I'm looking at page 82. Now, you have garden ground in front of the property enclosed by a wall. You have a fairly wide grass verge and a road. I would say, from the look of this, a single track road. This is not a busy thoroughfare. There are no neighbouring properties likely to be upset by this development. I look back to page 49. The design of the conservatory, as far as I'm concerned, is in keeping with the property. I'm honestly surprised that this application came in front of us.
Thank you, Jim. Patsy?
Well, that's where the debate is, isn't it? Because if you look at 4.3 on page 29, policy H8, under alterations and extensions to houses, it will be supported where the massing scale, design and external materials are sympathetic to the scale and character of the existing dwelling house and its immediate neighbourhood. Well, I don't think the immediate neighbourhood is particularly relevant in this thing. It's about whether it is sympathetic to the existing building, and I presume our officers have decided that it's not because it's too big. And looking at it on the, if you look at that there, and if you look at the things on page 49, it is big. It does jut out a long way. Is it going to be to that dike virtually? Is it? That's a big addition to a small Galloway country cottage. Is it in keeping with that cottage? I would suggest it's not. Because of the size.
I think this is why it's a difficult one, because it's already happened in houses and cottages close by to it, and relevant to size, they're similar in size.
That doesn't make, sorry, Chair, but that's not what we're here to discuss today. We're here to discuss whether this is sympathetic to the existing building as an alteration or an extension. And I would have to be convinced that it is. And I'm not convinced at the moment.
Ivor, then Ian again.
Chair, looking through the papers, I must admit, I think it's quite a big extension out the front of the house. However, I think you could actually make it a better design to actually make it fit in. If you go to page 18, now there's I would think it would be brown PVC design. Now, sorry, but to me that should never have been allowed on that property. However, if you go to page 20, another nearby cottage, the top picture shows two sun lounge extensions to front elevation. They tie in with the roofing material, and I think they add to the house rather than detract from it. Now, if it was something sympathetic like that, where the roof tied in more with what's existing rather than a glass roof, which I think doesn't tie in, I would have more sympathy with this application.
Ian?
I suppose the only point I was going to add here, Chairman, my view is still probably the same. I understand where Ivor's coming from. I've built a lot of conservatories. If it's approximately 12 foot by 12 foot external size, so your internal size is getting closer to about 10.5, 11 foot inside. Any less than that, you become a cupboard. Rather than that, it maybe look big in the scale of it when you see it there, but much less than that, it's not a conservatory. It becomes a cupboard more than anything else. I think Ivor brings up some relevant points about how it's designed and shaped and looked in regards to its external appearance, but because it's location, it doesn't really change my mind. Because it's location, it's rural, how domineering and what visual effect will it actually have as you're passing by, or the character of that building. For me, it's not enough to actually justify refusing it, and that's why, as it's come forward in a whole application rather than sectional, I think it's. And again, I probably treat this house almost back to front. Any conservatory that you'd build, you'd always naturally try and get to either south or westerly facing to gain the solar gain as well. It's a natural thing to do, but it refers to almost to that within the report when it talks to building inside out. People do tend to look inside your house, design it from an internal point, how it flows, so on and so forth. Solar gain and such like comes into that. So, my preference would be to support the appellant in this case and reverse the decision.
I wonder if I ask Robert, obviously there are conditions that apply to any planning application, and it would be the normal conditions, but if a condition was put in place for the roofing of any extension to have a similar one to the tiles that are there, would that be a
Chair, I would suggest that you probably shouldn't impose such a condition in this case, because it's been designed as a conservatory, so the load-bearing characteristics it has suit transparent roof, which is generally less of a load than a solid roof. You would change your solid to void ratio on the walls. If you're going for a conventional extension or a sun porch, you'd probably find you would need more supporting wall for that. So you might end up with something quite different as a result. I think in this case, obviously, there's a reason for the refusal, which is the proposed conservatory would not be consistent with or sympathetic to the design, character and appearance of the existing dwelling house. And on that basis, the appointed officer thinks it's contrary to the Dumfries and Galloway Council Local Development Plan Policy 8 and the supplementary guidance, which includes guidance on conservatories. So, when you're looking at the decision, that's what you're looking at, and obviously trying to arrive at, a view, do you share that view or do you not? And if you're accepting it as an exception to policy in terms of conservatories and front extensions, it's trying to work out on what basis you're willing to support it, really. I'm not sure if that helps at all, but a condition changing the appearance of the conservatory, I would caution against that because you may end up with a totally different design.
Ian?
At that point, I mean, I know LRB is different from the Plan Application Committee, and I suppose the only point I'd like to look through in regards to this, I mean, taking on board that it's quite clear, it's set out in 5.1 on page 31 of this report, the reason for refusal, and you just spoke about that, Robert, but going back to the comments that's been made, if you actually take case officers, planning, professionally trained planning officers, they've took different views in regards to very similar cases in that locality as well, and I think it's at our gift as a local review body, is my understanding, to do the very same. We don't really have to justify or make an exception. We would in the plan application, but when it comes to the local review body, if we interpret this a different way, I think that's our own desire.
Patsy?
Just on that, I mean, presumably we do have, if we change, we have to have, say we're going contrary to policy if it's not fitting with our policy, do we? I would have thought.
Yeah.
Just for clarification on that, Claire?
Yeah, it's outlined in the start of your papers. The LRB should consider first whether the proposal is in accordance with the plan, if not, consider whether there are any material considerations of weight, of sufficient weight to justify departure from the plan. Reason for any departure must be recorded. So we do need to put in reasons if you're coming to a different view.
I suppose, Chairman, the question I've got in the back of that, how do we square that with the previous delegated decisions, or almost like for this? I mean, that's what's hanging out there for me, as again, if we're taking that, I mean, one planner has got a completely different view on the same policies to another planner, so to speak. So, I mean, it's at odds with that is with itself. It's no problem to get a form of words in regards to reversing this.
Robert?
Chair, my advice would be you've had an appointed officer that's determined the case and they've arrived at a conclusion that's been supported by team leaders, so it's not an isolated decision. But in terms of your role today, you've got, as a local review body, you've got to determine this case against the policies in the local development plan and other material considerations. So you've got to decide, you've got to look at this proposal and then decide yourselves whether it complies with policy OP1. Does it comply with policy OP2? Does it comply with policy 8? These are the relevant policies. Supplementary guidance is also relevant too, and that's in the papers too. So what you've got to do is kind of compare, if you like, what you've got in front of you with these policies and decide, okay, does it comply with that or not? And if you feel it does comply, that's sufficient to overturn the decision. If you feel it doesn't comply with the local development plan and other policies, but you still want to support it on other material grounds, you can do that as well, as long as you're clear. So you might think, well, okay, this doesn't comply with our policy, but there are other things that I think are important in this case, and I'm going to give them sufficient weight such that it's an exception to the development plan. So it's really coming down to a process of interpretation, but first of all, you're holding up the proposal against your own policies in your development plan and the adopted supplementary guidance and trying to work out whether it complies with that or not. And if you feel it does comply, you're not obliged to look at any other material considerations, but that's the key first step. And it's only if you conclude that it fails to meet the development plan do you then start to bring other things into consideration that you feel might weigh in favour of a different decision.
Okay, so first of all, a couple of questions. First of all, do we have enough information, do you think, to make a decision today on it, going forward, members? And if we do, then what would you like that to be? I think we have enough information to make a decision today. I believe that the extension of the elevations is not contrary to policy 8, mainly because of previous decisions for in delegated powers. and that this application should be granted. Ian?
You know, I support your sentiments when you come to it. I think there's two things in particular. It's its rural location, very rural, and actually the orientation of his house, what's front and back's a wee bit confusing for me, but it is what it is, because there's not a street, but there's actually a road. But there's plenty of houses that have a road adjacent to them, classified or unclassified. But that is the actual, when you look at this, what's being classed as the front garden, as the back garden, and so on and so forth. So I mean, its orientation is a wee bit confusing to me. But when it comes to the being consistent, I think, of approach in regard to previous decisions with the exact same local development plan, have sympathy in regards to what you've said. I think we have to be consistent as a council when it comes to our approach. Maybe it's I can understand when you look at the very black and white, when you actually look at the policies, you look at the guidance that we've got here in the local development plan, it is very black and white when you see it. But I think for the sake of, I've still, like I say, I would support regards. I feel it actually, in particular because it's rural setting, because of the previous decisions that have been made, in line with the exact same local development plan, in the same locality. I think for the sake of being consistent, I would move to reverse the decision, same as yourself, Chairman.
Patsy?
I would have to disagree. I think it does not fit with our policy H8, alterations and extensions to houses, because I think it's an overdevelopment and it's not sympathetic to the scale and character of the original building. I also go into the conservatories on page 76, the information there, where it says exceptions may be justified for appropriate design conservatories where this is part of a traditional character of the area. I think this is not an appropriately designed conservatory. I think we've seen some that are and would have been accepted if they had had a solid roof and complemented the roof of the cottage. But this glass roof is not in character, and I do not think that I would uphold the delegated decision.
Anybody else? Ivor?
Chair, I have sympathies to Councillor Gilroy. It was highlighted that there was a delegated report, plans approved 25th of February. That was for a replacement to what was already there. It clearly states that at the bottom of the page. So therefore, there is a difference in that case where you're replacing something. An officer would take into account what was already there. If you go through the other ones, I don't know if the information is there that delegates, that they were delegated, because the one on page 18, that could also be a replacement to what was already there, the roofing section. And I don't think this actually complies with our plans. It's H8, I think, it's been quoted, and therefore I would move that we dismiss the appeal.
Okay, so we have two. I'll take it we can go to. Yes, Jim.
The grounds for refusal state that the conservatory would not be consistent with or sympathetic to the design, character and appearance. Now, I take the view that it may be slightly on the large side, but there is a consistency. The roof is ridged rather than a flat roof, and certainly you have a neighbouring property on page 18 with something I would not have considered sympathetic. I think this certainly is significantly better than what you have on page 18. And I would be prepared to make an exception for this particular application. I think we do need to show a consistency in the application of policy.
So thanks very much. I think, are you happy with the both?
Chair, it's just a question in making your decision. Are you taking this as an exception to the terms of the development plan? That seems to be what's suggested.
Yeah. Can we go to the vote now?
Sorry, my apologies. I've only got one motion that was proposed. I've got everybody's given their views, but
But
I'm happy to second that.
oh, sorry. The motion was by myself and seconded by Councillor Carruthers, and the amendment was proposed by Councillor Gilroy, seconded by Councillor Hislop. And obviously, whatever the outcome, the recommendations will have conditions applying to it.
I don't think in this case, given the nature of the development, I don't think we would need any conditions attached to it. You would just grant it outright without any recourse to conditions. I think the key thing is understanding the reasons for departing from policy, so that we can record that in the decision.
Scribbling away here. Got a motion proposed by the chairman, seconded by Councillor Carruthers, basically to reverse the decision of the appointed officer and grant permission as an exception to policy on the grounds that it need to be consistent with the previous applications granted under delegated previous applications, and also with regard to the rural setting.
That's it.
The fact that you're trying to be consistent, a reason for departing from policy when you think that perhaps we got it wrong the last time, which I would suggest was done, so that two wrongs are not going to make a right. I wouldn't have thought that was a good enough reason to go to exception to policy, just because something else is there that has gone through one way or another.
If there were any conditions applied to it, I might go along with what you're saying, but there's not going to be any conditions applied to this particular one because it's an extension under policy H8. I think from a perspective of planning, previous applications and things, I think, need to be taken. So we have to be consistent with our policies. But at the end of the day, I'm not going to sort of, give advice why I think it should be. It's going to come to a vote. At the end of the day, let's get down to it.
I've set out the motion. I've got amendment proposed by Councillor Gilroy, seconded by Councillor Hislop, to uphold the decision of the appointed officer and refuse. Okay, so going to the vote then, Chair.
Motion.
Councillor Carruthers.
Motion.
Councillor Gilroy. Councillor Hislop. Councillor McComb.
Motion.
Motion is carried, 3 votes to 2.
Thanks very much, members. We'll now go on to item number 5, which is St Mungo's Arms, 18 Main Street, Lockerbie, refusal of plan permission for change of use of public house to ground floor flatted dwelling. Do you want to take us through this?
Yes, thank you, Chair. Again, you've got your notice of review and related documents, report and handling and related correspondence, observations of the appointed officer on the applicant's notice of review, planning application form, associated plans and supporting information, decision notice from Dumfries and Galloway Council, relevant extracts from the local plan, and the photos of the application site and locality. The grounds of refusal are on page 144, being in the absence of further supporting information requested on 28th July 2017 with regard to the need of a marketing assessment, the Council as planning authority has insufficient information on which to form a proper judgment on this application. As such, it has not been demonstrated that the proposal complies with the provision of the Dumfries and Galloway Local Development Plan as set out in Policy CF1 and associated supplementary guidance. You have the requested method of determination on page 92, being that the applicant has requested that the review be dealt with by means of an inspection of the land which is subject to review. And you have the grounds stated in the notice of review in summary, being that the applicant has provided that there is a bigger demand in for housing in Scotland as opposed to multiple drinking establishments. The premises has not been advertised, as the applicant has said he was under the impression that the policy of retaining community facilities would only apply to last licensed premises in the village, the applicant has provided that provisions of the LDP policy CF1 are noted, but after having obtained 2 property valuations in 2010, it was reluctantly decided that the sale of property would not provide a sufficient return to sustain a modest income in retirement for both myself and my brother, combined with the fact that my brother would have been required to purchase the accommodation of its own. Having obtained these valuations, it was agreed that my brother would remain in the flat above the premises and would continue to run the public house until his death, having been diagnosed with a terminal illness from which he died in late 2016. The applicant has advised that there were very few customers. It was only financially viable to keep the bar open in recent times because my brother did the vast majority of the bar work. The profit generated was only sufficient to pay the running costs and occasional wage for any part-time staff that were employed. The income that was generated would deter any prospective buyer. The applicant has advised that he suffers from ill health and is no longer able to manage the premises or attend to any legal matters in respect of the premises. The market for licensed premises is not as buoyant as it has been in the past. The Drovers on the High Street has lain empty now for well over a year. The Ravenshill Hotel in Lockerbie is also struggling to find a buyer, having been in the market for a number of years. Lockerbie has a population of around 4,300, and if you exclude off-sale premises, there are currently a total of 16 licensed premises competing for the same trade in a declining market. Given the number of licensed premises within Lockerbie, the council can be satisfied that the Mungo Arms is surplus to the needs of the community, as well as the fact that alternative provision of equivalent community recreational benefits are readily available within Lockerbie. The applicant has advised that no objections were raised when the proposed change of use was advertised earlier in 2017, and he has already received interest from a number of persons wishing to rent the premises if planning permission is granted. The applicant is of the view that Lockerbie needs additional housing, which is what he wishes to provide to ensure that the premises continue to provide a service to the community and not just become another empty or derelict building on the High Street. He has further comments from the interested parties of the development plan policies. So the main issues for the LRB to consider are: does the proposal conform with the relevant development plan policies, and critically, does it comply with Local Development Plan Policy CF1 and associated supplementary guidance? If not, are there any material considerations which would indicate that planning permission should be granted as an exception to policy? So again, having outlined the papers, it now falls to the LRB to determine whether it has sufficient information to consider the review. It's confirmed that, again, there's no representations held from any parties today, and the Chair, again, will lead you through the papers for this case.
Thanks very much. Again, we'll just go through the photographs first, and we'll go through the different points for clarification. So, Robert.
Thank you, Chair. Just looking at the first picture, this is the existing premises on Main Street. This is looking towards the northeast. Now, in the actual papers, you will see existing elevations on page 135 and proposed elevations on page 137. But in effect, there's very little change to what's there as existing compared to what is proposed. If it's also helpful, on page 139 you have the existing floor plan and you have the proposed floor plan as well, showing how the conversion is intended to work. So you've got another very similar photograph. It shows the existing frontage to the public house. Then this is more of a street scene this time. You can see the premises. This is looking north. The application site is partly obscured. It's behind the white dwelling house on the right hand side there. This is from Mains Meadow to the east of the site. You can see the application site there. And again, that's mirroring the kind of elevational plan you get on page 135. So you can see the kind of hip roof element protruding from the back of the building. This is the side southern elevation of the application site. So this is the affected building. And again, this is tallying in with the plan you see on the top right of page 135. So that's that elevation.
Thank you very much. And we'll go through the index of context for clarification, members. So you've got the notice of review and related documents, pages 89 to 96. Any points of clarification? Patsy. We're looking for points of clarification. Notice of review and related documents, page 89 to 96. And then we have the report on handling and related correspondence, pages 97 to 120. Patsy.
It's the letter on page 109, and I just kind of wonder why it's here. Because there's not much of it really. I just don't understand what it's doing here.
The reason it's before you is because it was in front of the appointed officer when that decision was made. It's a crucial part of the applicant's case that they weren't well enough to go through the marketing exercise. Now, this has been heavily redacted for data protection reasons to protect the applicant, but basically what it is showing is qualified GP has given the view that the applicant wasn't well enough to submit that marketing assessment. So that is simply all that is. You know, it's just giving a professional view, if you like, that corroborates what the applicant is saying in his submission. And again, because it was in front of the appointed officer when the decision was taken, it's felt important that you have that in front of you now.
Okay. Jim?
Thanks, Chair. It's the only manner in which demand information can be supplied through the conducting of a marketing exercise.
The key issue here, Chair, is when you look at policy CF1 as it appears on page 152, it does say in the last paragraph, and it's actually at the top of page 153, that the policy says in the case of commercial facility, alternative uses will only be considered favourably by the Council if it can be demonstrated that despite marketing the site for at least 12 months, there has been no viable interest from other commercial operators. Further detail is contained in supplementary guidance. You've obviously got the supplementary guidance in the papers as well, starting on page 155, so that is what the policy says, and the appointed officer looking at that policy and thinking it hasn't been fulfilled because the marketing assessment hasn't been submitted. So the decision is very much based on that. But the policy CF1 in the LDP as it stands is specifically looking for that to be done. Yes.
So that is indeed, Chair, the only way in which the demand information can actually be shown.
It appears that way unless there's local knowledge and, you know, actually.
I mean, talking of exceptions like we were in the last one, surely with this letter on page 109 from a GP to say that Mr. Johnson was not fit and able to do such a thing, surely that should be considered an exception to our rather stringent policy.
I'm not sure if health matters actually come into planning policies, unfortunately. I'm going to seek some advice on that from Robert.
Chair, sorry for the delay. I'm just looking for the appointed officer comments relative to that. And I think the key thing really here from the appointed officer in response to that question is paragraph 7, so it's at the foot of page 123. And it says, in the event that marketing of the site had been carried out following the original request in November, which showed insufficient market demand for existing use, then officers may have been able to reach a different conclusion by now. However, it currently remains the case that the marketing assessment is outstanding, and the matters raised in the letter sent 8th of August 2017 by the case officer have not been addressed. Then it comes on to the ill health issue. Without this clarification, it is not considered that the information provided in relation to applicant's ill health would constitute material grounds which would outweigh the requirement for a marketing assessment in this instance. That is the appointed officer's view in relation to that question.
So we then go on to the planning application form, associated plan support information, page 127 to 139. Any points of clarification? And then the decision notice from the Dumfries and Galloway Council, pages 141 to 147. Any points of clarification? We've then got the relevant extracts from the Dumfries and Galloway local plan, pages 149 to 158. And then we have the photos of the application site and locality, pages 159 to 166, which we've seen in Robert's initial viewings on the overhead. So, sorry, Ivor.
Chair, it was with regard to the extracts from the local plan. When we read through page 156, and it says, this may apply, for example, to safeguarded business and industrial sites where a change of use could lead to the loss of employment land, or for a building which provides a community benefit, such as a public house or shop. Now that's singular. Does that mean to say that if you have a facility that is the only pub or shop in that area, that policy applies to it? Or should it be such as public houses, where it would actually be, if it was any public house in a facility, an area, it would apply to it? Because as it reads is, if you've one pub in the area, you would have to go through this, rather than if you have numerous pubs and you want to take one out.
The way the appointed officer has looked at this is, if the focus of the application is a public house, it's then considered a community facility, and you go through the assessment set out in the supplementary guidance. It wouldn't need to be, I mean, the appointed officer's view is it wouldn't need to be the last pub in that village or town. It would just be, if the focus of the application was a pub, you would go through that process. So, I mean, I would read it the same way, to be honest. You know, if I was looking at that and it was a similar application for change of use of a public house, regardless of location and how many pubs were in that location, I would think, well, this is a public house, so I would apply that supplementary guidance to this. So I don't think it has to be, my interpretation is it doesn't have to be the last public house in a settlement.
Ivor, you want to come back?
It also says it's for community benefit. Numerous reports from NHS, etc., say that the sale of alcohol is not a community benefit. So how can we justify a public house as being of community benefit?
I don't think Robert can speak on behalf of the NHS, but I'm sure he'll have something to say about it.
But, I mean, in terms of, I have looked at this before. I have looked at policy CF1 and questioned whether a public house is classified as a community facility in terms of that policy, and it is, the policy does define a public house as a community facility, so policy CF1 is relevant. There maybe is a debate to be had there about that, but, you know, as far as your existing policy goes, a public house is identified as a community facility.
Jim?
Chair, at the present moment, there is absolutely no community benefit. The premises have been closed for some time.
Thanks for that. Ian?
Chair, we're at the point where we can, like, almost like in session, or we still have to make a decision of, all right, okay.
I was just going to come to that, Ian. I think members, do we have enough information, first of all, to make a decision on this one? And if we have, can we open it and get into a discussion about that? So if we are, happy to move into discussion. Ian?
Thanks, Chairman. Same approach as last time, maybe. I mean, I think looking at this in its own merits, previously as convening licensing board, obviously one of your existing roles, but we understand in the locality of Arndale and Eskdale, it was, where this is right in the heart of Arndale and Eskdale, what is the licensing trade like in that area? I think across Dumfries and Galloway, it's pathetic to say the least. It's on its knees, whether this pricing policy has an effect in that as well. Some feel that it will. This new national pricing policy that comes in on alcohol units may well benefit the health of the nation. You never know. There's arguments either way, but that's one thing. So as a local person, certainly know, is there an actual a thriving licensing trade in Arndale and Eskdale? No, there's not. In Lockerbie, no, there's not. This would, in fact, if this was to turn into housing, I would imagine it would probably help the existing licensed premises in that area become more sustainable financially. We're looking at, suppose when I looked at this, I thought, well, what further information have we got since the determination of this, which I think was back September time last year? And I noticed in November, the appellant's letter, I should say, states quite clearly. So there's further information after that point that we can see is that there's 2 premises within that area. One's actually fallen derelict, never mind because it's inactivity. One's been on the sale for a number of years, can't be sold because of its lack of, I suppose, its business capacity. It's kind of, if it was a profitable business, it would sell. Let's face it. So here we're looking at number 3, and somebody's actually being proactive, trying to diversify and saying, listen, we want to actually change the use to housing. We know there's a local need and demand in Lockerbie, in this area. We have that evidence as a council through the local housing strategy, housing needs and demands assessment. There is an actual need there. So for me, there is evidence that actually says, for by, quite clear, there hasn't been enough information going black and white by our policies. But I've got enough knowledge personally. Hopefully there's other members within this committee today that can relate to that as well in regards to. I think the evidence here, we've got two existing businesses that are up for sale and can't be sold. Well, one's up for sale and one's becoming derelict. This business is trying to move a transition. It is on its knees, the actual licensing industry, I think probably across Scotland, never mind Lockerbie or Andy or Nestdale. I think under the circumstances, we've probably got enough information to make a decision to actually reverse the decision rather than uphold the appeal.
Any other members? Patsy?
I'm looking at page 96, and which is really following on from Councillor Carruthers. And if we were sitting in another committee and there was an application in for another licensed premises in Lockerbie, I would suggest that we would probably turn that down on over-provision and a surplus to needs or requirement, if I'm being honest, because I think there's 16 licensed premises. I think that's enough for a town the size of Lockerbie, I would have to suggest. And I'm not surprised that some of them are having to close, because I think, as we've just heard, that there's a decline in this industry at the moment, and I don't think we want another derelict house or premises on the streets of Lockerbie. So in this instance, I would suggest that, although we go against policy because we haven't got the required marketing information, I get that, but we've got information of another kind from just personal knowledge and understanding of housing needs of the public house situation. And I would suggest that we let this premises be developed. And I would go along with that. If that's a proposal, I would second that. Ian.
Ivor?
Chair, I think if we look at policy CF1 under the reuse of existing community facilities, when we're considering it, we need to be satisfied that the facility is surplus to the needs of the community. Well, I would have thought there would have been objections if we were removing this facility. However, it's been closed for about a year. My understanding is, therefore, there doesn't seem to be a need for the building. There would be an overall community gain from the development. Well, I think if we bring housing into the area, it is a community gain. An alternative provision or equivalent community recreational benefit is made available at a suitable location within the local area. Well, there are 16 other licensed facilities, excluding, was it off sales and supermarkets, or including them? I can't remember what the word was. I realise that the next paragraph does say that in a commercial facility, alternative uses will be considered if there is a marketing. However, I think that there is enough to demonstrate that A, the economics of the licensed trade do not support the number of premises, or else you would actually see more being looked to be open. This one hasn't. There's evidence, I know, in a different town in here, where we've had a pub not far from here which took £30 from 10 o'clock in the morning to 11 o'clock at night. That's being staffed. There is no way that is viable. And through other hats of being on the licensing board, you hear all the publicans squealing that there's no economic justification to invest in their pubs. So I would actually think that although there is no marketing of the site, the economic realities of the area are that public houses, where there is other provision, if they're not needed, they should be allowed to actually just be redeveloped. And I think the community benefit of having a flat there would be a reason to allow that.
Okay, thanks very much. Jim?
Thanks, Chair. I think this case illustrates the fact that the supplementary guidance is too narrowly drawn. The supplementary guidance insists on a marketing exercise taking place. Surely, an analysis of public houses and how long they have been in the market, how many on-sales licenses have been surrendered, that type of information could suffice for a 12-month marketing exercise.
I don't want to make policy on the hook or anything like that, Jim. At the end of the day, there is obviously the local development plan and policies, and that will come forward through that to try and enhance what we already have in local development. And it is at the moment on the consultation period, and I think if you were to put that forward as part of the consultation, that would certainly be taken into consideration. I do agree, however, in this case that that there is enough evidence with what you have suggested as members of this local review body that a reversal of the decision made by the officer would be a pertinent way forward. It would, of course, have to be an exception to policy. Do you have enough information of why that would be reversed?
Chair, having listened to everyone quite carefully, I think it is clear it's recognised that in this case, you've got to determine the application in accordance with the development plan unless material considerations indicate otherwise. It's quite clear that, given the terms of policy CF1 and the supplementary guidance, this would be an exception to policy if you are minded to overturn the decision. It sounds like, if you're looking for material considerations that are persuading you, I think the applicant's submission is key in that. So we're talking about the applicant's letter of the 25th of November, which was submitted as part of this review. So that's pages 95 to 96. I would suggest that what you're looking at here is maybe you're minded to approve this development as an exception to policy on the basis of a quite unique set of circumstances as outlined in that letter, and make specific reference to it, because then you've got a unique set of circumstances to this case. You're not hidebound with further decisions, but obviously the policy would remain the same going forward, if you like, until such time as it's changed. In defence of the appointed officer, I think the appointed officer's gone along, followed the policy and guidance, and got to a point and thought, I need a marketing assessment, asked for it and not received it, at which point they thought, well, we don't have much option here other than refuse the application. So if you're minded to support the application as an exception to policy, it's maybe things like, the applicant's letter of the 25th of November that you maybe want to make specific reference to in the unique circumstances of the case.
Yeah.
I'm very supportive of that. I referred to a couple of things in it, but use the whole letter, I think as a whole, it's a good idea. And just to pick up, and I picked up the exact same point as what Robert did. I felt very much that the case officer here had been doing their hardest to try and, I suppose you could say appease, but I certainly come to some kind of liaison with the applicant here. And they've clearly stated that because of the lack of information, they had no option but to actually refuse it. So the right thing was to come forward to the local review body and let the members of the council decide it.
So remember, we come to the decision that we were reversing the decision of the appointed officer, which is an exception to policy, and the reason we're given is the applicant's letter within the papers, and be a set of conditions. I would imagine the normal conditions for any planning application to go forward with that.
Again, I'm not persuaded it's necessary. Normally for a flat or a dwelling house, you would have something requiring car parking, but there's obviously on-street car parking available here. There's not really any significant physical changes to the building externally, so I think you'd probably be safe enough granting it without conditions, to be honest with you.
Okay, are we happy with that, members? Okay, thanks very much. I have no further business. Thanks very much. Sorry, Jim.
Very briefly, Chair, I think it is important that we consider the implications for the wording of supplementary guidance. That, perhaps a broader definition may well be more appropriate.
I think the council's doing representation to that anyway, so, Robert?
I mean, what I can do, Chair, is I can bring the decision taken today and the reasoning for it to the attention of the council's local development plan team leader, if that would satisfy members.
I think that would be a way forward, members. Right, well, thanks very much, members. I'm no further business, and I'll close this meeting. Thank you.